Okay, I'm live, apparently. All right, this is Dave Zick, and I just got hooked up today, which is wearing around my neck. It's a chemo delivery system, and anyway, so I'm beginning that process again. This is my how many times? Okay, so I've had 3 independent cases of cancer. God, how many times have I undergone chemo? Well, um, it's safe to say that I've spent over 2 years of my life hooked up to chemo um, in total. Anyway, so as always, I'm optimistic, mainly because, well, one, that's the kind of person I am, and two, it makes no sense to be otherwise. It's always, you'll find better outcomes if you're optimistic than if you're not. And anyway, all right. Well, maybe I should talk about my potential lawsuit for a little bit. As you all are aware, probably, if you're listening to this at all, I was homeless. Before that, I was a college physics instructor, or tutor, physics slash engineering. I did mathematics as well. I taught mathematics. Well, I taught mathematics and physics at a community college. Before that, I was chief scientist of a tech company for a short period of time before they went. Before it was around 1989. It was the crash of tech industry. Anyway, um, so I became homeless after I ran out of money after I had cancer for 5 years, and then I lived off of my savings and for 10 years. Um, and I um, find myself in Fort Collins, Colorado, um, living here. And anyway, I lived in my car for 3 years. 2 years, the last 2 years, my car was disabled, not very highly functional. But I kept the tabs in order, and everything was fine, except for I ran amok to a law in Fort Collins called camping, which is 17-181. And when I read the law, I was really confused. It didn't make any sense to me because it seemed to imply that it's illegal to be a homeless person in Fort Collins. It's illegal for a homeless person to be in Fort Collins. So let me recount how this happened. Well, the law begins as such. It's Fort Collins City Ordinance 17-181. The first sentence describes that it's illegal to camp or to pitch a tent or to permit anyone to camp. That's fine. That's very easy to understand. The second sentence defines camping suchly. Camping shall mean to sleep, to spend the night, to reside or dwell temporarily, with or without bedding or other camping gear, and with or without shelter, or to perform activities of daily living, such as eating or sleeping at such place. Camping shall not include incidental napping or picnicking. Well, first, there's some minor problems with this statement, with this definition. First of all, it is really presumptuous of the city to say camping shall mean, because meaning is something done after interpretation. And the city does not elicit any interpretations. So camping doesn't mean that. Camping is defined as that. Um, Second of all, such place is not contained within the definition itself. So in order to find out what the meaning is of such place, one has to go to the first sentence And in the first sentence, there was only a mention of one place, and that place is public property. So such has a search for a place in which meaning can be attached to such place, and there is only one place, and that's public property. So it makes sense. 17181 is a public property camping law. So such place is public property. Okay, now why did this law confuse me? Well, I have a history of understanding things very quickly and almost instantaneously, byproduct of something that was discovered when I was in the second grade about some sort of unique aspect of my personality, which I won't go into here. It's not unique. It's only sort of, I'm on one of the far ends of a bell curve. So, there's about 1 or 2 million people in the world who are just as far flung. Anyway, getting back to this law. So I lived in my car. Fort Collins has many homeless people. There's something called the HUD, Point of Contact Study, which is done each year, which tries to count the number of homeless people. And it since the law was created in 2006, for each of those years, the HUD count, has counted more people who are homeless than the city has provided homeless shelters to accommodate homeless people. So there's always going to be homeless people each and every night who can't get into the shelters. And in point of fact, it's even worse than the HUD pig count shows. There was a study done in between 1982 to 1985, which showed very carefully that the HUD pig count at that point undercounted by at least a factor of 10. Now, there's a local homeless expert here in Fort Collins who thinks that the factor is more like 6 here, that there are 6 times as many homeless people as shelters placed, but that's not important. The important fact is that there are more homeless people than homeless shelter available for them. So the homeless people are forced to occupy spaces outside of homeless shelters during the night. Some homeless people. We can call them extra homeless people just for convenience. All right. If you're interested in the law, you might note that there always exists some people for whom the Martin-Boise condition is satisfied now. A condition of the case, Martin-Boise. But we don't need Martin-Boise. We can use it if we want to. We have much stronger arguments than Martin-Boise. All right. So anyway, my point is this freaking law is totally confusing unless you analyze it as Justice Scalia would have preferred, which is as a textualist, which is to place the meaning, common, ordinary parlance meaning to each and every word, to ascribe each word the meaning in accordance with it, to not ignore the meaning of any words, and to put it all together. And if you do that, you get some incredible things. Okay, now let's take a step back. What is the definition of ordinary camping, colloquially speaking, out of any dictionary that you might pick up? And I looked at a bunch of dictionaries. I looked at British dictionaries. I looked at an English dictionary from 1910 as well. And in every single case, for every single dictionary that I looked at, which is it's about 15 to 20 dictionaries, the meaning of the word camping there's several meanings, but the relevant meaning, one has to do with the activities outside of one's house normally, not in terms of like campiness, camping or whatever, is to occupy a camp. And then if you look up what camp is, it's fixed relative to the ground. So camping, colloquially speaking, is an activity that happens at a place which is fixed relative to the ground. Now, in one's ordinary sense, if one limits the number of possible camps on public property to be one, and that camp is public property, then we can, this sort of ordinariness of the word camping can be, it can be just dealt with and favorably so. But in another sense, if you don't even, like the city doesn't do that. They say these people are camping at camp, right by the river or whatever. In that sense, it just doesn't jive, because if we look at the definition of camping, it's to satisfy one of four verbs: to sleep, spend the night, reside or dwell temporarily, or to perform activities of daily living. So anytime one of those four verbs is satisfied on public property, camping has occurred. So performing these verbs can be done in a variety of ways. One could be driving down a street on College Avenue, say, which is a main thoroughfare of Fort Collins, and eating a sandwich or chomping on Cheetos. And then, camping shall mean to sleep, spend the night, reside or dwell temporarily, or to perform activities of daily living such as eating. There you go. So camping is driving and eating. What about sleeping on the bus? Camping shall mean to sleep. So if you sleep on the bus, that verb is satisfied. However, you're not fixed relative to the earth. You're actually in motion relative to the earth. You're moving. However, so but that doesn't matter, because that's the colloquial definition of camping. The reason that the plain language, the camping, I argue, is a plain language technical phrase, is because of, if we use camping in the nilly-willy, it will be very confusing to people who read it. So it should have an asterisk. Camping, asterisk, technical, plain language, constructive, technical meaning. Unless there is only one camp in Fort Collins, public property, and that is public property. Now, let's look at why that should be in another way. The word camp is not defined in this law, in this subsection, in any definitions place in section 17. So we have to work backwards to figure out what it could be. What could a camp be? Well, if you work backwards and make the reasonable definition that camping, or that a camp is a place where camping occurs, you will find that there is only one place where it occurs in this definition, in this law, and that is such place. So the camping occurs at such place. And if you ascertain what such place is, there's only one possibility, and that is public property. So that means that there is only one possible option for what a camp is in Fort Collins, and that in this section, and that is public property. So it makes sense that you could be driving and eating Cheetos and be camping, because you're driving in the camp. You're performing a camping activity, eating On the move, it doesn't matter because all it is to expend verb. Okay, so anyway, you get that point. All right, so now we can make sense of what camping is in Fort Collins. Like, in the same way that a logician would make sense of some sort of string of symbols, or a computer programmer would make sense of a computer program. I mean, how else are we supposed to interpret this, right? Because if you just interpret it the normal way, it means that it's illegal to be homeless in Fort Collins. You can't be in Fort Collins at night as a homeless person. Okay, well, it ought to be unconstitutional then. So anyway, that's just a generalized introduction to it. Now, as far as the potential lawsuit that I'm considering, I don't want it to be frivolous, and I'm worried that some lawyers might think that it is. But when I got 3 camping tickets when I was homeless. The first one I was assigned a lawyer, and he lost. I lost $100. I had to pay $100 to the city, and actually it was $125 because it was a late fee, because the judge put my due date on the final day of the month, and I should have objected. It should have been the first day of the month. I'm on disability, and I didn't have any money, so I get paid on the first. So getting back to first of all, do I have standing to sue civilly here? Right. I mean, I'm living within a house, and I haven't gotten a camping ticket in a year and a half. So what I would be doing is suing for civil rights violations that occurred 3 years prior to that. And I will argue that they are continuing today for something that has to do with 17182A, which I will go into much later, but not in this tape. So the question is, how are my civil rights damaged? And do I have standing during this 3-year period of time? Well, the easiest way to get standing is for a First Amendment right to have been violated. Because of the case Elrod Burns, and because of subsequent interpretations of Elrod Burns. So all I need to do is show that my First Amendment rights were violated for even the most minimal period of time. And then this triggers the conditions imposed by Elrod Burns. Now, the version of Elrod Burns that I like the best is the one that was brought up in the case against Andrew Cuomo by the Catholic churches or whatever. And I don't have that memorized. I don't have it in front of me. If I develop this, well, it's trivial to look up, but it'll just be, I'll have to edit. I don't know how to edit. I'd have to edit this tape if I did that. So how do we get, first of all, how do we get First Amendment rights violations? This law is so encompassing that it ought to be possible, right? Because it makes it illegal to do anything practically. All right. Well, the way that I like to get to get it is by incorporating the second. Okay, first of all, let us partition this law into the definition of this law into 4 clauses. Okay, lawyers call this, well, judges call this severing. Legal theorists call it separability. Professor Fallon, who is probably the leading expert in the world on facial challenges, likes this term. So all that it means is you don't have a law which is totally twisted up. Like, you can have clause 1 referring to clause 2, referring to clause 3, referring to clause 4, referring to clause 1. And so these things would be intertwined and entangled. sort of like a quantum system, like a whole bunch of qubits which are entangled. And I mean, if you know anything about quantum mechanics, or if you know some graduate level quantum mechanics these days, you'll know that there's no basis by which to separate these. I mean, from a mathematician's point of view, there's no Gram-Schmidt orthogonalization process to separate these into mutually distinct, mutually disjoint and jointly inclusive set of statements which are equivalent to the entirety itself. So, but we don't have a problem like that. In this law is very simple. It's hard to understand because it shatters the mind's sensibilities about what it is to be a human being and how human beings can make it illegal for other human beings to live. So, but in terms of actual understanding of it, if you just pretend that you have no sensibilities, I suppose, it's very easy to understand, and it is separable. It's severable, and it can be partitioned into 4 clauses. And the second clause is to spend the night. Okay. All right. So here goes the argument for standing. Okay, I'm using L. Rod Burns. So L. Rod Burns triggers something called irreparable harm. Irreparable harm is a sufficient condition for standing in civil suit. So, okay, if it's illegal to spend the night on public property as a homeless person, an extra homeless person who can't get into the shelters, where are they to stay? They can't stay on private property because of 1740 and many other things. Private property, the legal ability to stay on private property is up to the property owner. The ability for a homeless person to be on private property, they have no rights to be on private property, such as the right to guest or to host of the private property owner. So homeless people have no right to be on private property during the night, and they have no right to be on public property for the entirety of each and any and every night. Why? Because if they did so, they would be spending the night. That means that it is necessary. It's necessary for each homeless person to leave the city, because the city consists only of private and public property. There's no way to disprove this assertion by looking at the zoning laws, because private property is not, or public property is not defined. So, all right, the argument goes, therefore, it's illegal for a homeless person to be in Fort Collins during some period of time during the night, the period of time in which they have left the city. That means it's illegal for that was to be in, but their very existence cannot make itself known in the city during this period of time also, because they're not in the city. And it makes it illegal for a person to be in the city for the entirety of the night, so they must be elsewhere. They must be, their entire being must be elsewhere. Therefore, their right to be expressing their First Amendment options are violated during this period of time where they have to be elsewhere. So, for how long of a period? However long it takes for them to leave the city and to come back. Well, this automatically hits the criterion expressed in L. Rod Burns, where even the most minimal periods of time in which one's First Amendment rights are violated triggers irreparable harm. It meets the condition of irreparable harm. And that's the only argument really given by the Catholic Church. They're talking about like 2 hours a week for some people numbering over 10. So it's the same argument, basically. So, all right, so we have standing. Okay, so we can sue. And what are we going to sue for? Well, I'm going to sue for damages done by my civil rights violations. In particular, it will cost $2 every night to take a bus to leave the city when it's possible. And in the summer, the condition of nightness has not been met before the city stops running. So it would cost even more money. And if you add it up for 3 years, that's about, well, let's see. 3 years is about 1,000 days. $2 that's $2,000. If you multiply by a factor of 7 to 10, depending upon which lawyer will be representing me, what they want, that's roughly $20,000 plus. During the summer, it would cost even more. Anyway, and this is just the most basic civil rights violation, the one just used to meet standing. But if you look at, I mean, this law imposed cruel and unusual punishment upon, I would argue, every homeless person in Fort Collins, but it's only been proven in court to have applied to Adam Weinmold. But I have many arguments for this. I mean, the most simple argument is that if it's illegal to be in Fort Collins, it's illegal to be addicted to the use of narcotics in Fort Collins for some minimal period of time each night, which violates Robinson v. California in 1962 and hits cruel and unusual punishment. Now, I know a lot of judges won't like this argument, but there are many better arguments. Okay, I'm going to end my tape. I have a good night. Bye.